opportunity to discuss any of these exhibits that you would like to address and provide the court with your testimony as to why the court should not continue the petition at this time. So, sir, can you please state your name and your current address for the court's record?
My name is Zachary Toler, and my address is 317 Len Street, St. Mary's, Ohio, 45885.
All right. How come you think you no longer live with that address? Have you moved back to that address?
It's undecided in court. There's an active case. I'm just staying place to place.
Is that where you want the court to send all mail?
Yeah.
You change your address once, and then so I just want to make sure that that's where you want your mail. All right, I'll let you update the court then. All right, so now, sir, is your opportunity to be heard. The court will hear any evidence. You also have a right to dispute any of the exhibits that were presented in court. So if you'd like to see copies of those exhibits or discuss any of those exhibits, they are available to you. You have a right to not incriminate yourself today as well, sir. I reminded you of that at the beginning of the hearing, but I'll remind you of that again at this time for your benefit. To provide any testimony today,
yes,
sir?
sorry, I was.
That's all right. That's all right. This is your opportunity, Mr. Toler, to provide any testimony that you would like the court to hear, or consider any evidence, or dispute any of the exhibits that have been presented through their testimony.
Well, I'm going to dispute all of the exhibits, but not one at a time. I'm not going to speak for an hour because it's unnecessary. So the first one would be, where's the court order that says that I'm not allowed to have contact with Charlie, with our daughter?
We're not asking questions, you're providing testimony. Are you wanting to ask the...
Okay, testimony.
Yes.
She filed a civil stalking
I
protection.
believe this exhibit AA is what she presented to the court as it relates to any contact you have with the minor child. So you're welcome to see this.
Yeah, I think I have it.
You're welcome to dispute any allegations that Ms. Swartz made today in the court.
Okay, for exhibit AA, this is a decision, not a judge's order. So that means that the court hasn't adopted it, so it's not in effect. Unless a magistrate can give orders, but I don't believe that they can.
Well, okay, so you're disputing that you're not able to have, you're disputing whether that you're not able to have, that court order is not in effect at this time, or I'm not exactly sure what you're saying that that's not in effect at this time.
So
all right.
Anything that she used that for is void because that's not in effect. The order that is in effect goes back to August 30th, 2018, which is Standard Rule 14, Local Rule 14, Parenting Time Allocation.
So you believe you have the ability to have contact with Charlie
Yes.
at this time? Okay. All right. Can you discuss some of the contacts that she believed you've made either through Facebook or through her directly that were concerning to Ms. Swartz? Do you want to tell the court about those things?
Yeah, why is she stalking me on Facebook? My personal page, Zach Toler, is set for parody and satire. So anything they use to make me appear delusional, I have the page set to satire and parody. That's the point. And as for my governor page, I'm an independent candidate for Ohio governor, and I am running on integrity, transparency, and accountability. So I post about fraud and corruption. Ms. Swartz got the civil protection order just so she could block me from having contact with Charlie and violate the parenting allocation.
Are you disputing any of those Facebook posts as accurate?
I'm disputing them as irrelevant. How did
Not relevant.
this is supposed to be a stalking, a no contact order against me, but she has pulled everything from my public and private social media. So that would be stalking.
Are those private posts or those public posts?
The ones that are under, oh, I have her blocked on my Zach Toler page, my personal page. So she's obtaining them through a third party, which would be stalking.
Are you disputing whether they exist?
Am I disputing whether my Facebook posts exist?
Yeah, whether those posts actually exist. Despite how she may have obtained them, are you disputing that whether they're true and accurate copies of the Facebook posts for which she's alleging you posted?
Oh, I assume that they're Facebook posts.
Okay. Do you have any other testimony or evidence you want the court to consider as it relates to the contacts?
No, why am I supposed to provide evidence? I thought the burden of proof was on her.
The burden of proof is on her.
Okay. I would like to see the check with $20,000, or the 15 that says it's any different. Let's see here. I would like to see any record of domestic violence. I would like to see evidence of anything she stated.
Protection order. The burden is under a statute, revised code 2903.214. That's what the burden is at this time.
Yeah, that don't mean anything to me. That's a number. Let's see here. Is it 1, 2? I guess we could just go down the list here. Let's see, number 2. Did I follow her? No. There was a canceled court hearing in Mercer County on August 28th. I went to see if she would appear for the court hearing.
Mm-hmm.
And she did, which was weird. As for me tracking her via GPS, is there any proof of that whatsoever?
She's indicated that it came from a Facebook post. Do you want to dispute that?
My daughter Charlie recorded her own abuse, and in the background of the recording, her GPS is giving oral directions. I didn't track GPS. The recording picked up the GPS. We're still on number 2 here. I've never seen, well, first of all, I don't have any of the medical documentations that she said in that same video she provided all up to Mercer County. I haven't been provided with any medical documentation. There's no sensory processing disorder that I'm aware of. I didn't become belligerent when I asked for records. I asked her for records. I have that recording as well.
Do you want the court to review that recording?
I don't have it with me.
Okay.
Doesn't she have to prove that I was? Anything she said I was, she has to prove. All she has is evidence of her stalking me on Facebook.
We have testimony, and testimony is evidence, and the court will determine the veracity and the accuracy and the reliability of each witness based on the testimony. So that's what you're getting to do now. She's had her opportunity to be heard, and I want to make sure you have your opportunity to be heard, sir. So you have any ability to tell me any evidence or testimony that you believe is contrary to the statements that she's made today?
Yeah, everything she said, the exact opposite is true.
Okay. Can you explain to me what you mean by the exact opposite? That you didn't make these posts, or you didn't make these statements online? You're saying the exact opposite, so I want to make sure I understand exactly what your testimony is.
She's projecting all of her behavior on me. Yes, I made Facebook posts, but they're true and I'm allowed to make them.
Okay.
First Amendment speech.
Yes, sir, but you said the exact opposite of what she said, and so she went through a number of Facebook posts that are sitting right beside you.
Yeah,
You're
really.
welcome to go through to discredit those posts. If you'd like.
Why do I have to discredit the post?
You don't, that's your opportunity, sir.
Yeah, no,
Right,
I don't want to discredit this post. I don't care if there's a civil protection order against me, but I want to be able to contact my daughter. I haven't talked to her in 40 plus days. That's what this is about. There's no court order restricting me from seeing her. That's why I filed for kidnapping, because that's what it is. She blocked me for 40 days from having contact with our child, and there's no order saying she's allowed to do that. That's why she got the civil protection order.
All right, so just to clarify, sir, she filed a petition to have no contact between the two of you. And you just stated that you don't care that there's a civil protection order between the two of you so long as your daughter's not on there. To my knowledge, she has not included your daughter as a protected person. So are you willing to agree to the protection order being in place so long as...
If I am allowed to contact her about our daughter, that being the caveat. That's the only reason I have to contact her at all. She doesn't have any proof that I drove by her house on any of those days. When she reported on January 5th, I was sitting in the courtroom at the same time it was reported at 3 o'clock, 1,500 hours. Didn't admit to being there. It was, how could I be here and there at the same time? So, Exhibit E, her purchasing the taser for being paranoid doesn't have anything to do with me. That's not evidence of anything. Exhibit D. All right, do that. Exhibit F. Yeah, that was Facebook posts. Exhibit G. There's no proof of her being harassed for welfare checks. The reason I would call the police for a welfare check was to have a welfare check for my daughter, because I haven't had any contact with her.
So you're admitting that you're the one that made the welfare request to the police departments, and...
I did on
She
February.
indicated 6. Have you contacted
February.
them 6 times?
No, I called them on February 9th, I believe. Yeah. It was the day after I lost contact with Charlie. Yeah, I object to all of her evidence unless she can provide the $20,000 check, the medical documentation, anything that she mentioned. And that's it. I don't care if this is a protection order, but I want the caveat, the exception that I'm allowed to inquire about my daughter. She has to give me my daughter's contact information. Then I don't need to contact her. Actually, no. I don't want that at all, because this is just bad record. I object to everything.
All right. And can you tell the court why you believe you need the $20,000 check? What is?
Well, yeah, because if there's $20,000 cash exchange, which I have on video, then that is child endangerment. And she said that she has a check for $15,000 something, then that's important. Because then she could actually disprove what she says in the video. But there's zero evidence. Got hours of video of her abusing her daughter. The reason she blocked me was because then our daughter can't tell me about her abuse.
She hasn't included your daughter in this civil stock protection order, so the court's not making any determination as it relates to your minor child. The court has jurisdiction over that over in Mercer County.
But that doesn't solve the problem.
For no contact between the two of you.
Yeah, and I object, because how has she used the civil protection order this far? She's filed false reports and she's blocked me from having contact with my daughter. That's unacceptable. That's kidnapping, that's abduction, that's interference with parental rights. It's parental alienation. And yeah, I filed criminal complaints because that's what you're supposed to do when someone commits a crime like kidnapping a child.
Do you have any inquiry of the petitioner at this time?
So, I mean, do I get to ask her questions?
Well, if they're directly related to the issues that she's brought before the court will allow some limited questioning if it's relevant.
Yeah. Ms. Schwartz, do you have any evidence other than hearsay testimony that I drove through your alley on multiple occasions? Any pictures, any video evidence? Okay. Do you have a $20,000 check that you've referenced multiple times?
No.
No?
She said no.
No. Do you have any proof of domestic violence ever? Any documents, any court documents, pictures?
She has her evidence that she's presented today, sir. You're welcome to
Yeah.
discuss
I know that doesn't exist because I don't have any domestic violences. So. You said that you were familiar with the vehicle that was driving through the alley? What is the vehicle?
It was a silver Honda.
Silver Honda. Do you know the year? The newer one, older?
She said no.
No. I don't own a silver Honda. Okay, well, there's no evidence of stalking her. She submitted that. She said the wrong car. And everything else is wrong. There's no orders restricting me. There was no police standoff. They didn't have legal authority to enter my home, so I didn't come outside. That's pretty simple. What was number? Oh, that was another. She says Javi was witness to me driving by. Yeah, root check invoice. That's supposed to cover the 20,000. Yeah, no, I mean, she doesn't have any evidence of anything except what I posted on Facebook. And there's nothing about that stalking other than her stalking me.
All right. Mr. Wilbacher, do you have any questions of this witness?
Would you look at exhibit AA?
How is this one?
Would you turn to page 9?
Yep.
On page 9, it says decision. That's referring to the decision of the court, correct?
Yeah, yes.
Would you look at item number 5 under decision?
Yes.
Could you read that, please?
Effective immediately, the minor child shall reside with defendant and plaintiff shall have parenting time pursuant to the following schedule. and I'm not reading all that.
And number A, what does that say?
Does this have a judge's signature on the bottom?
That's it, sir, you're not allowed to inquire with the attorney, he's asked you a question.
Well, I'm objecting because this is irrelevant without a
All right,
judge's
well,
signature.
I'm gonna go ahead and ask you to answer. What is A?
He wants me to read A. I'm not.
Read it. I'll read A, and you tell me if I read it correctly. No parenting time shall be ordered for plaintiff, in this case, you were the plaintiff in this matter, until he or she obtains updated mental and emotional assessment. Plaintiff has, or may obtain said assessment at a facility of his or her choosing, or at Foundation Behavioral Health Services in Salina, Ohio, that provides contact information. Plaintiff will provide an unredacted copy of his or her assessment to the defendant, in which case this is Brittany Swartz, and her attorney. Did I read that correctly?
Sure. I don't understand how this is relevant. If it's irrelevant, don't I get to object to it? Since
You can object to what relevancy, if you prefer to object, sir.
yeah,
All right.
So,
I object because
Over-
there's no judge's
overruled.
signature.
The court does find it relevant at this time.
And so, according to that order, there was to be no contact between you and Charlotte.
Objection is not an order. It's a magistrate's decision, so he can stop calling it an order. That's not what it is.
You were served with a copy of this magistrate's decision.
Yes.
You were given an opportunity to object to the magistrate's decisions.
I objected to the magistrate's decision.
All right, and did the court adopt the magistrate's decision?
Not that I am aware of.
All right. Do you have any evidence that the court did not adopt the
I
magistrate's?
think the evidence is on view.
I'm asking if you have any evidence.
You can answer if you're aware, no, and if you don't know.
No, it's an absence. If it hasn't adopted it and issued a document, then no, it's still the decision.
I actually looked at page 13 of that document.
Okay.
And on page 13, under line item 13, there's a reference there to our family wizard. Do you see that?
Yes.
And it was the order of the Mercer County Juvenile Court that all communication between you and Ms. Swartz was to be over our family.
Objection.
Is
It's
that correct?
not an order. He keeps calling it an order.
All right. Do you object to what line 13 says?
No.
All right.
Nothing further.
Anything else, Mr. Toler, you want the court to consider today?
Yeah, consider that anything that references that has no value because it's not a court order. It's a decision. And she didn't provide any evidence for her allegations about me driving through a rally or anything else other than Facebook posts that she shouldn't have been able to obtain without a third party. Because my profile, my personal one, is private. And I want to see and talk to my daughter. That's all I want.
I understand. I've already told you that the court doesn't have jurisdiction over that issue.
She uses this as a tool to stop that.
Exhibits. All right, the court is going to run through the exhibits. Exhibit A is the magistrate's decision. Exhibit double A, excuse me. Any objection to the exhibit double A?
Yes, objection.
And what is your objection, sir?
It's not a court order.
I didn't say it was court order. I said it's a magistrate's decision dated January 20th of 2026. Do you have any objection to the court receiving exhibit double A?
No.
All right, court will receive. Or no objection. Exhibit A is a motion to dismiss the CPO in case number 14 DB of Mercer County. Any objection to the court receiving that motion?
Yeah, objection because it's not relevant. That was 10 plus years ago.
Walker?
Your Honor, that exhibit was offered just to lay a foundation for the background of this case and the reason that Ms. Swartz has a fear and trepidation of Mr. Toler based upon her history with him.
All right, any follow-up on that?
Well, of course, she's afraid because she's abusing our child and committing medical fraud, and I expose that.
Do you have any further objection to the dismissal?
No.
Okay, so the court will then receive Exhibit A. Exhibit B is the motion for parenting times is from August 8th of 2025 in the Mercer County Juvenile Court. I believe this is your motion, Mr. Toler. Do you object to Exhibit B?
No.
Okay, court will receive Exhibit B. Objection. Exhibit C was a text from you. This is a multiple page document. Stating that you swear to Jesus if you or BS ever corner, tailgate, or gaslight Charlie, you will lawfully destroy both of them, and that's a promise. Do you have any objection to the court receiving Exhibit C?
No.
We receive. And Exhibit E, I believe, is a screenshot of a video of Ms. Swartz leaving the courthouse. Do you have any objection to the court receiving Exhibit C?
No.
D, we have Exhibit E. This is taser. Proceed.
Yeah, objection. It's not relevant.
All right, Mr. Walker.
Again, Your Honor, that was offered to, lay the foundation that Ms. Swartz does have a genuine fear of Mr. Toler, and she's taken action as a result of that fear in order to protect herself if necessary.
Objection. The taser, how is that supposed to protect her if I'm this delusional, unstable person?
All right, well, the court's going to allow it for that limited purpose, so the court will receive it over objection. Exhibit F is,
I believe that was the, Your Honor. Oh, I'm sorry.
I'm just going through them in order that they are presented. Exhibit F is a request for medical records and a complaint for jury trial. Mr. Or any objection to Exhibit F?
Is that my federal complaint?
Yes, along with,
You know what? Yeah, objection to it because it was posted online and she's blocked from my profile.
so you're objecting on how she received this document?
Yeah.
But isn't she a defendant in this lawsuit? Wouldn't she have received a copy of this, sir?
She would have if the federal marshal served it to her.
Alright, so you still object to the document, Exhibit F?
Yes, I object to how it was obtained, because it reveals that she's stalking me.
Okay. Mr. Walker?
Yes, Your Honor, it's posted on a public forum, available to the public, and, again, is,
What public forum?
evidence of the delusions that Mr. Toler seems to be operating under.
Objection. How is filing a federal complaint evidence of delusion?
Well, we're not gonna go over the substance of it, I'm just trying to decide, whether it should be properly admitted as evidence. So you're objecting based off of how she obtained it. The court is going to, accept Exhibit F over objection. The court will receive, Exhibit F over objection by Mr. Toler. Exhibit G. This is again, another emergency motion complaint for violation of constitutional rights, through the Northern District of Ohio, the Western Division, filed by Mr. Toler, case number 325 CD 2248. Mr. Toler, do you object to the court receiving Exhibit G?
No.
All right, the court will receive that over no objection. Exhibit H is a Facebook post, Mr. Toler's Facebook, dated November 3rd, November 5th, 2025. Sir, Toler, do you have any objection to Exhibit H?
Yes.
All right, what is your objection?
It was obtained from my private profile where she is blocked, and it has false information like tracking GPS.
You are indicating this is a private post, but the court does see that, no, but that this does provide for a worldly post.
But she's blocked from my profile.
All right. Comments on the objection?
Again, Your Honor, this was a post made on a public forum. Whether or not Ms. Swartz is blocked or not, they came into her possession. I believe this post is another one of the posts that's making a call of action or making a call to action. Therefore, we believe the bill is ready.
You know what? I just accept them all.
All right. So Exhibit H, you're withdrawing the objection.
Yes.
All right. The court will then receive back. We have Exhibit I, Exhibit J, Exhibit K, Exhibit M. These are all additional Facebook posts, and so you said there's no objection to the Facebook posts?
Nope.
All right, no objection. The court will receive them over no objection. Exhibit N, Exhibit P, Exhibit Q, R, S, P, U, V, W, X, Y, Z. And you said you have no objections to any of the further exhibits. I just wanted to put them for the record.
No.
No further objection. We'll then receive them over no objection.
Your Honor, I believe in that article there is Exhibit O in there. That would be a duplicate of Exhibit AA. So
Did I mention O?
No, you did not, but I believe it got put in the packet that you
I
have
don't
there.
think I have it.
No, okay.
O?
Well, I pulled it out. Oh, okay, I pulled it out.
I don't believe I have it. I've named all the exhibits the court has in its record. The court has received all objections. Exhibit E and F were received over objections. The rest of them were received over with no objection. So the court will take this matter under advisement. I'd like to remind everyone that the current ex parte order is still in effect until this court makes an order. That ex parte order is still in effect through, let me double check. I believe it's March 30th, but let me state it on the record. Before I allow everyone to go, I just want to make sure. Yes, the expiration of the ex parte order is March 30th, 2026. That will remain in place until this court makes subsequent order. The court will take this matter under advisement. Mr. Toler, make sure you keep your address up to date through the clerk's office. I think you have to update the clerk's office if you have a new address or have reverted back to an old address. It is up to you to make sure the clerk knows what address to send any subsequent orders or for service purposes. So the court is taking this matter under advisement. And Mr. Toler, you are free to go.
Thank you.
I'll allow you to leave first, and then Ms. Schwartz, you can leave a few minutes later.